Hello, and welcome to the Freddie Mac Connect Managing Default Everything You Always Wanted to Know panel. All lines are in listen-only mode. This session is being recorded and will be available following the conference. If you have any technical issues, please use the Q&A box as well and someone will assist you. Lastly, using the handouts icon, you will find links to speaker bios and the presentation deck. With that, I will turn it over to Dean Meyer, Business Analyst Senior with Freddie Mac. Dean, the floor is yours.
Welcome, everyone. Thank you for joining us today for a chat with some of our managers of our single-family non-performing loans department here at Freddie Mac. Again, I'm Dean Meyer. I'll be the moderator for this session. I have with me today Steve Tate, manager of our LawSmith team, Deloise Brown Milner, manager of our foreclosure and bankruptcy team, and Jeff Williams, manager of our RPA team. In this session, we plan on focusing on delays in the default space, best practices for submitting and settling workouts via Resolve, and common issues we see in the RPA space. With that, let's get started. Steve, what's your team focusing on for the remainder of 2023 and into 2024?
Thank you, Dean. And hello, everyone. So for us this year, our primary focus has been to work closely with our servicers in reviewing and resolving issues related to severely delinquent loans, particularly loans that are 2 years plus delinquent, not yet referred to foreclosure, and in a supporting role, identifying workout ineligible borrowers and encouraging servicers to consider more exception submissions for review to Freddie Mac. All that being said, what are some of the challenges that impede the goal of issue resolution? For us, there are three areas of opportunity: reporting discrepancies, strategy and partnership and with servicers, silos in communication, and functional roles. So in terms of reporting discrepancies, post-COVID, we've noticed issues with default reporting, specifically in terms of accuracy in reporting loan status. For example, loans are reported as delinquent on our system, but root cause analytics and discussions with servicers, we are finding loans are actually performing or current. Another example is Freddie Mac loans show as seriously delinquent and not referred to foreclosure in our system, but are actually already referred to foreclosure. Silos, again, at times a separation of duties when there is no transparency with business partners and stakeholders can lead to breaks in communication, and that includes systems. Far too often, these silos are not visible until an issue actually arises, leading to more difficult conversations and prioritizing break fixes, which likely could have been avoided. And then my last point regarding strategy, when there is not a concerted effort in thinking and acting strategically, whether holistically or loan level tactics, issue resolution is difficult. So for both Freddie Mac and servicers, a commitment to work together strategically, meetings to discuss loans, talking through the challenges in partnership and without optics getting in the way of making progress has been very impactful in getting to the root of problems and solutions.
Okay, we're working well with servicers. Servicers are working with borrowers, and it's time to look at a workout. A borrower doesn't qualify for a delegated workout, and the servicer needs to submit it to Freddie Mac for review. Steve, what would you say are good examples of exceptions being submitted to Freddie Mac via Resolve?
Great question. Firstly, quality submissions are at the top of the list, ensuring that good notes are included that justify the exception submission. Addressing the fatal warnings. These fatal warnings are flags for servicers to understand why a borrower was ineligible for a particular workout type. So in identifying those fatal messages and being able to provide justification for exception review, that's very important. Also, understanding perspective and philosophy, that hardship, for example, hardship resolution and affordability are key factors in a clear decision, and providing notes to qualify that. And lastly, within Resolve, the info requested feature is a really helpful tool because it gives both Freddie Mac and servicer the ability to communicate while a file is in review. Seamless communication and ensures a quality review and decision.
Okay, Steve, what are common misconceptions with understanding the Freddie Mac exception review process?
Yeah, this is always a tricky discussion. Commonly, not enough exception submissions are coming over to us. And the familiar theme is we don't always know what should be sent to Freddie Mac for exception review in certain situations. My answer to that is simple. Err on the side of caution and send it to Freddie anyway. Remember, we are here to review exceptions to the guide. Let us help you in making that judgment call. It's always safer to send than to not at all.
Okay, great. So now we've got a modification approved. They settled it. The servicer settled with Freddie Mac. Steve, can you explain what are post-settlement data corrections and why are they needed?
Yeah, interesting topic, particularly with the fact that the goal is to complete a workout without any hiccups post-settlement. So to answer the question of post-settlement data correction, it allows the servicer to address any discrepancies between the modification agreement, their internal system of record, and Freddie Mac's system of record after a workout is settled. When the discrepancy is identified, a data correction can be submitted to Freddie Mac via the servicer data correction tool to remediate the discrepancy, prevent future edits, and to ensure the correct reimbursement amount is paid and that servicers have been properly compensated. Again, the goal is to reduce and limit data corrections as much as possible. It takes time for both the customer and Freddie Mac to deal with this. So ideally, we shouldn't have any. However, if there are errors, we believe the implementation of Resolve will reduce the need for data corrections, as Resolve will make the determination to share the exact terms that Freddie Mac expects for the workout. For those servicers already on Resolve, we're already noticing a decrease in their percentage of post-settlement data corrections.
Okay, excellent. So now, Steve, when a correction is needed, how long does the process take, and what are some of the best practices to ensure the updates are made as quickly as possible?
So typically the process, SLA, is 60 days, usually less. Keep in mind there is a two-part process to manage on the Freddie Mac side. Initially, there is the submission, which requires a review. And if approved, that second step will require a master file change to update our systems. What do servicers need to do? Well, most importantly, servicers need to ensure accurate and timely completion. In addition, servicers must provide the required documentation, specify what data corrections are needed to be updated, and to be sure to include comments and justification. Lastly, to reiterate, it's important to note that the initial request is complete and accurate to ensure the Freddie Mac team receives a complete submission with no need for additional information.
Okay, so now all workout options have been exhausted and foreclosure is the only option. We'll now turn to looking at managing foreclosures. So Deloise, what are some of the trends you see in foreclosure timeline delays?
Well, Dean, thank you for that question. I would say compared to a year ago or even 2 years ago, most of our delays surrounded forbearances, loss mitigation attempts that were tied to the pandemic. Fast forward to this year, most of the delays that we're seeing definitely involve litigation. I'll give you our top 4. The first delay that we're seeing is routine litigation. In these delays, borrowers are alleging that there were missed opportunities for loss mitigation. This also includes allegations for missed opportunities pertaining to HAF. As you would recall, HAF, the Homeowners Assistance Fund that was implemented by the federal government to assist homeowners that were impacted by COVID to allow them additional relief for loss mitigation. It's a federal program, however, it's run by the states. States have varying application processes and timelines, and many times we're hearing that borrowers are delayed to no fault of their own. Some of the litigation that we're seeing, the borrowers are claiming that they're not being allowed enough time to pursue these federal programs. Just as a reminder for servicers that we would prefer to see delays to the foreclosure timeline to assist borrowers with loss mitigation. And in addition to any pursuit of federal, state programs that they might be involved with. We would rather, case by case, extend the timeline than have these loans be impacted by litigation. The second category would be allegations of procedural delays or servicing violations. Some examples of that would be challenges to the statute of limitations. So, for example, in the state of New York, last December, the governor of New York signed into law the Foreclosure Abuse Prevention Act. This law provides for a very strict interpretation of foreclosure timelines. There's a 6-year statute of limitations with a lot of focus on when that loan was accelerated into foreclosure. As a best practice, our servicers should be working very closely with their law firms to identify any loans that are at risk within this category. Within the procedural allegations as well as alleged servicer violations category, we also see challenges to standing. And that basically means that the borrowers are challenging that servicer's right to even raise a foreclosure action. We also hear about allegations of bankruptcy violations. So again, very important that the communication between the servicer and the law firms are very clear. You're identifying loans where there's risk and then escalating those issues to Freddie Mac. The third group of delays that we're seeing pertain to bankruptcy filings. What we're observing is that borrowers who did not receive sufficient payment relief under loss mitigation, or maybe there were delays to the loss mitigation process, they're filing for bankruptcy. We're particularly seeing an increase in our Chapter 13 bankruptcy filings. And I think it's an indication where borrowers are seeking a broader relief for all of their debts versus just the mortgage payment. And last but not least, title concerns is our next largest fourth delay. We're seeing anything from missing assignments, lost notes, challenges to our lien priority. We're even seeing homeowners associations as well as the condo associations being a lot more aggressive in enforcing their liens. The importance of managing these delays, Dean, it's not just a matter of time and cost, but by managing these delays proactively, we're also reducing any reputation and legal exposure for Freddie Mac. As you know, my team engages pretty regularly with servicers as well as their law firms, digging into these delays, seeking to find the root cause of the delays to create strategies where we can either resolve the issue, minimize the delay, and then move forward with the foreclosure process. For any of our servicers who are listening today and you would like to be engaged, similar to what I just described, please feel free to reach out to me after this session. So thank you for that question, Dean.
Okay, when there are delays in when there are delays in the foreclosure process, that usually means contested foreclosures and possibly additional property preservation that's necessary to be done at the property. When that's necessary, servicers need to spend more money, and that requires filing an RPA to Freddie Mac through PAID. Now, Jeff, what is your team focusing on in the RPA space?
So thank you, Dean. Our major focus for the rest of 2023 and for 2024 is improving the RPA decline rates. So in order to do this, we came up with 3 paths. So the first path that we came up with, we noticed that many RPAs are being declined due to missing information or user submission error. We partnered internally with our training team here at Freddie Mac and created an RPA submission tutorial called RPA the Right Way. This tutorial is not how to submit an RPA, but rather focuses on the RPA submission process itself. It provides important details on best practices such as submitting quality RPAs, such as what to include, such as acceptable backup documentation, as well as outlining what should be covered in a submitter's comments. I encourage every servicer and their vendors to take this training. Now, the servicer link is located in our contact slide, or if you can't find it there, you can always email the MPL mailbox and we'll be happy to send you a link to that training. Now, the second path that we've come up with is we have developed, in conjunction with our pay team, 3 daily reports, which are available through the Reports tab in Paid. These 3 RPA reports focuses on the RPA status. So the first report is an approved report, second denied, and the third is released. The report shows RPAs that were decisioned the previous day. They are broken down by submitting vendor and contain comments from both the submitter and from the reviewer. The approved report will allow users to identify anything that was approved so work can be ordered and can be started. The denied report will identify why, in detail, the request was denied. And the released report will identify what is needed and what would be helpful to obtain an approval of the request upon resubmission. We're hoping that these reports will be used as training tools and workflow aids with both servicers and their vendors. Now, the third and last path we've created is an internal appeal review process. So all RPAs that were denied and then are subsequently appealed, we are looking at not only to review again for decisioning, but also for completeness and accuracy of the comments used in the original denial. This internal check ensures that we are providing a consistent and a clear message to the submitter on why the denial was made. If we find discrepancies in our decisioning, then we can address this internally with the entire team and take it as a training opportunity moving forward.
So great. So one of the things I want to talk about is we all know the importance of working together with servicers. So I'm going to ask each of you a question about what you think we can do to work better with servicers. So Deloise, I'll start with you. Sometimes a borrower is contesting a foreclosure or has filed a bankruptcy to stay the foreclosure process with the goal of remaining in the house. What can servicers do to seek resolution?
Thank you for that question, Dean. When we're dealing with contested files, even where a borrower is filing multiple bankruptcies, we look at those as being engaged borrowers, even though they're engaging in a manner that we would prefer them not to be. The first thing that I would suggest to servicers is when dealing with contested loans is to try and determine intent. What is the borrower's intent? By establishing the intent, whether the borrower intends to keep the property, and that's the reason for the litigation, or if the borrower intends to walk away from the property, helps us to structure the correct resolution or strategy for that particular file. So for example, if a borrower's intent is to keep the property, it might be possible on a case-by-case basis to look at some type of exception loan modification terms. If the borrower's intent is to walk away from the property, then we know that we're looking at liquidation options, which could include exception deed in lieu terms. Maybe we're looking at extended vacate timelines. We could consider consent to judgment in exchange for cash for keys. So these are just some of the things that we can do on a case-by-case basis. Now, when servicers are approaching us, there are some pieces of information that should be included as a best practice. The more information that you can give us upfront, it facilitates the review and allows us to give you a quicker response on the recommendation. So besides telling us intent, you should also include a copy of the complaint. We would also like to know if the allegations being raised by the borrower have merit. If errors were made or there was some other type of servicing violation, we would need to know so that we can partner with you and assist you in minimizing the risk around that particular file. Be sure to include information such as the property condition, property value, the state that it's in. We would even like to know the stage of the litigation. Again, all of these pieces of information allow us to partner with you in resolving the issue. So good question, Dean.
Okay, so Jeff, earlier you talked about best practices in the RPA space. One of the things that I'm always curious about is, what does your team do to promote transparency with servicers to be consistent in RPA decisioning?
So Dean, maintaining consistency with the services are utmost priority. So there's a couple things that we have done. So the first thing is we have set up routine monthly calls with our servicers and with their vendors. Every servicer is assigned a primary point of contact, and this primary point of contact has a recurring monthly call with each servicer regarding RPAs in the RPA process. During these calls, we discuss trends and issues we are seeing with their submissions. We're talking about guide updates, as well as our overall decisioning philosophy. We're hoping that these meetings will create an open dialogue and discussion and improvement for improvement opportunities, as well as create a sense of transparency in the RPA process. The second thing we're doing is we have an internal weekly meeting, as well as we use daily our Teams chat. So maintaining consistency is a key, because not only does it affect monetary risk, but also reputational risk. One of the primary ways that we maintain this consistency is by encouraging open discussion amongst the team. So using the team chat, we make sure to ask questions on a daily basis, to review RPAs together if there's a sense of confusion or we're just not sure exactly what's being asked for. We also carve time out during our weekly team meetings to discuss the best practices and difficult decisions that we've encountered during the week. We also share recent topics and trends that were discussed with our servicers on the monthly calls to make sure that we're all on the same page when we're talking about a certain expense code or an issue. And lastly, we also leverage our relationship with other teams here at Freddie Mac. We openly collaborate on challenging files with our MPL partners, such as the folks here on this panel, Dean and Steve and Deloise. This partnership allows us to make the most fact-based decisions when reviewing RPAs.
Okay, great. So let's move on to Steve. For workouts, what does a quality submission include from a data and comment standpoint, and so we can make quality decisions?
So Dean, but before I actually get into that, let me first say Deloise did a great job in stressing the importance of communication and EDR reporting. Both points have equal importance and impact in the seriously delinquent but not referred to foreclosure space as well. Now, regarding workout exceptions, an increased focus on quality submissions, specifically with providing accurate data and thorough comments, are critical to quality review. So in terms of data and comments, the expectation is that with any exception submission, all necessary data fields are accurately completed. That's baseline. And with respect to comments, the goal should be to tell the story of the borrower's circumstance, addressing their hardship, along with notes to justify the reason for exception review. All are equally important. Lastly, as I mentioned earlier, the info requested feature in Resolve. Not only does this feature serve as a means to communicate on status of a workout with the assigned loss mitigation representative, but to also answer any questions.
Okay, great. So we've got a couple minutes left, and I have one last question for each of you. So I'll start with you, Jeff. If a servicer loses access to paid, who do they contact?
Good question, Dean. So each servicer has their own paid administrator in-house. So in order to get a password reset, to get new users set up, or to get additional user roles, they would go ahead and find that servicer, administrator, and contact them. For anything above that or beyond that they need to troubleshoot, I would encourage them to call 1-800-FREDDY. They're the best people that can actually help you in paid. Everyone in Freddie on my team and on our floor, we cannot access or help you with any user setups or password resets.
Okay, great. So DeLuise, Freddie Mac just announced in a recent bulletin changes to our attorney firm requirements. Can you speak to them?
Yes, Dean. So you're referencing the bulletin that was released early in October. It's bulletin number 2023-20. In this particular bulletin, Freddie Mac advised an alignment with Fannie Mae as it pertains to our minimum firm requirements. Please reference Guide Section 9501 for complete discussion. However, some highlights of the changes include allowing law firms to continue to operate in a post-pandemic hybrid or remote working environment. We've updated our requirements around law firm attorney qualifications, as well as the residency requirements for attorneys in certain jurisdictions. And last but not least, we removed the requirements for law firms to have at least one lead attorney handling Freddie Mac's default matters. It's extremely important that servicers follow all of the requirements of Guide Section 9501 in addition to the changes that have been announced. These changes take effect in February of 2024. However, we are highly recommending that if servicers can make the adoptions from now, it's feasible, please go ahead and do so. Part of the requirements I just wanted to note was around reporting. ADR reporting, law firm reporting, is one of the minimum requirements that Freddie Mac expects servicers to have oversight of with their law firms. We use this information internally at Freddie Mac to help target loans and proactively identify issues where we can partner and collaborate with you to seek resolutions. Please feel free to reach out to me if you have any questions pertaining to ADR or to the bulletin announcement that was released in October.
Okay, great. So Steve, at times data corrections requests are denied due to errors with the submission for not having enough information. How can we do a better job to avoid mistakes with the initial submission?
Great question. There are a few common mistakes or just questions in general, what we see or typically see with submissions. So if a servicer is unfamiliar with how to submit or understand what data is required and why, or even how to appeal a decision, or if timeline decisions are a question, the best approach would always be to email our post-settlement correction mailbox. Responses are within SLA and managed by a team that will be able to answer any questions and provide assistance in how to successfully submit a data correction request, or even answer questions pertaining to decision timeline updates.
Okay, great. Well, Steve, DeLuise, Jeff, it was great chatting with you. I hope we provided some relevant information for servicers on how to avoid delays in the default space, best practices for submitting and settling workouts via Resolve, and some common issues in the RPA space. With that, our session is over. I wanted to thank everyone for tuning into our session. I hope you learned something. If you have any questions, please reach out to any of us at the contact information that was provided. With that, I'm going to turn it back over to Amani.
Thank you to our esteemed panelists. Please take a few moments to complete our brief survey so that we can continue to bring you timely and relevant content. The presentation deck will be sent to you following the session. You can also log in anytime after the conference to play back this or any other session. Thank you and enjoy the rest of the conference.